Welcome to the Immigrant's Way with Margaret W. Wong and Associates. Today we have Attorney Francis Fungsang. Hello, Francis.
Hello.
So Margaret W. Wong Associates has offices for U.S. immigration law. We have offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. If you wish to arrange a consultation with the immigration attorneys, please call 216-259-8897. That's 216-259-8897. We're going to jump right into or let me first ask Francis, do you have any information or news on immigration that you'd like to share today?
Well, the big news this summer has been the new Biden administration policy helping families stay together in the United States. And that's intended to help people who are married to U.S. citizens and also their non-citizen children, who are stepchildren of those U.S. citizens. And so that policy is going to get into some more detail in the next few weeks, but the administration has already announced that August 19th is going to be the first day they'll accept the applications. Now, we don't know what those applications are going to be yet because that hasn't been published yet, but that'll happen in the next 2 weeks.
So on August 19th, will the federal government publish it before the 19th?
Well, they'll have to publish it before the 19th because they already said they'll start accepting applications on August 19th unless they decide to delay that process.
Okay, but your immigration attorneys won't know exactly what to file until the federal government publishes it.
Correct. The administration has already said you can start gathering certain documents. So what can you start gathering? Number one, proof of the marriage. So the marriage had to have happened on or before June 17th of this year. So the marriage certificate. Number two, you have to show that you've been physically present in the United States for at least 10 years before June 17th of this year. So June 17th, 2014 to June 17th, 2024. Any documents to show you've been in the United States for those past 10 years. And then if you have also you have to show that you came into the United States without inspection. That means you were not inspected by immigration. So if you came on a visa or you came using someone else's documents, this policy might not help you. Okay?
Thank you, Francis. This is Margaret W. Wong and Associates. We have offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. We are a national law firm, as immigration law is a federal law. If you wish to arrange a consultation, please call us at 216-259-8897. That's 216-259-8897. We have a question from a Facebook respondent who wrote this question yesterday, but he said, good morning, and I have a question. My wife and my daughter begged for asylum 8 years ago, and we started an asylum case with another attorney, but we lost the case and they were deported. Now my question is, can we remove that deportation and open a new case?
So the big question is going to be, you said that your wife and daughter were deported. That means that immigration physically removed them from the United States. Now, if they are outside of the United States right now, then technically there isn't really a way to reopen that deportation case because it's over and they've been deported, so that case is done. Now, they could possibly start a new case. And so how do you start a new case? I would not recommend just crossing the border illegally. You can use the CBP One app to schedule an appointment at the border to come through the United States legally to start a new case if you still fear that you'll be harmed or threatened in your country. Okay? There are some new restrictions that were announced earlier this summer about applying for asylum if you come into the United States illegally. So that's why you want to try to use the CBP One app even though it might be difficult to use or there might not be that many appointments available, try to use that so that you can be eligible to apply again.
Thank you, Attorney Francis. Again, this is Margaret W. Wong and Associates, the immigration lawyers in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. Margaret W. Wong and Associates is headquartered in Cleveland, Ohio, but we have these other offices around the country, and we're happy to have a consultation with you. We have another question here, Francis. Hi, I've been in the U.S. for 11 years. I have 2 kids. I came on a tourist visa. Can I apply for a green card through my children? They were born here.
Okay. U.S. citizen children can petition for parents for the green card in the United States if the parent came into the U.S. legally on a visa. Now, but the children have to be at least 21 years old before the child can petition for you. So if the child is under 21, then you have to wait until the child turns 21 before you can start that paperwork. If you are put into deportation or removal proceedings, there's a type of application called cancellation of removal or 10-year cancellation, where you've been in the United States for at least 10 years, you have a parent, spouse, or child who's a U.S. citizen or green card holder. That parent, spouse, or child would have extreme hardship. Life would be very tough for that person if you had to leave the United States. And you are a person of good moral character, no serious criminal record in the past 10 years, then you could apply for the green card with the immigration judge to remain in the United States. But that's only if there's a deportation case that's been started against you. You can't just walk into court and apply for 10-year cancellation.
Thank you for that answer, Attorney Francis. This is Margaret W. Wong and Associates. You may arrange a consultation with us by calling us at 216-259-8897. That's 216-259-8897. And a follow-on to that first question was if a person has been deported. So the first question was his wife and daughter were deported. If the person himself is deported, can they return to the U.S.?
Okay. And so how do you return to the United States? You could try to apply for a visa at the U.S. Embassy, but most likely that visa will be denied because you've already been in the United States before, you've been deported, and so they're not going to give you a tourist visa because they'll be afraid you'll just overstay your visa and remain in the United States. Well, coming into the United States illegally, we don't recommend that because it limits your options. If you come into the United States illegally after you've already been deported, immigration can reinstate your deportation order. That means they can use that old deportation order to deport you again. And so your best option to return to the United States and actually try to apply for some benefits here would be to apply for permission to re-enter. And that means using the CBP-1 app. Now, another way could be through sponsorship. If you were married to a U.S. citizen, or you've got another person who can petition you for the green card, it's possible that you can apply for permanent residency overseas through the U.S. Embassy and then be able to come into the United States as a permanent resident and get the green card.
So you mentioned the CBP app, the CBP-1 app. Presumably that's a telephone app?
Right, it's an app on your cell phone. And it's the Immigration Service started that because there were too many people lining up at the border. And this is an organized way for you to schedule an appointment to show up at the border so that you can ask for permission to enter and be interviewed about whether you can apply for asylum here.
Excellent. Thank you so much for that answer, Attorney Francis. Again, this is Margaret W. Wong and Associates. If you wish to arrange a consultation with an immigration attorney, please call us at 216-259-8897. That's 216-259-8897. Now, here's a very basic question, but a lot of people are wondering, who can be deported?
Well, technically, anybody who is physically in the United States and does not have lawful immigration status in the United States can be put into deportation proceedings, and if they're ordered to be deported, can be deported. Now, if you have a serious criminal record and you came into the United States with a visa, then the Immigration Service itself technically could give you an administrative final order of deportation without you even going to see an immigration judge. But if you came in illegally, or you came in on a visa and overstayed without a serious criminal record, and you don't have any other applications pending, then technically the Immigration Service can start a deportation case against you. And it's only if you lose that case with the judge and you lose any appeals, then the Immigration Service will use that final order of deportation to deport you.
So a follow-on question to that is, I'm a U.S. citizen. I was born in Mexico. Can I be deported?
So if you are a U.S. citizen, then you cannot be deported because you're allowed to remain in the United States and you have the same rights as any other U.S. citizen, whether you were born in the United States or not. Okay? There's no such thing as second-class U.S. citizenship.
Thank you. So undocumented immigrants, I'm sorry, we have another question here. TPS, this person's TPS was approved, but he was still detained. What can he do?
Okay, so if you have TPS, that's called temporary protected status. That means that the Immigration Service has decided that person's home country is too dangerous to return to. Then you can apply for TPS status, which gives you a work permit and protects you from being deported. Now, if you are detained and you have your TPS approved, then the Immigration Service should release you unless you have a criminal record, which makes it so that you are no longer eligible for TPS. Then the Immigration Service can revoke or cancel your TPS, which means you might have to fight your case in immigration court for deportation.
Thank you for that answer, Attorney Francis. Again, this is Margaret W. Wong and Associates with offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. If you wish to arrange a consultation with the immigration attorney, please call 216-259-8897. That's 216-259-8897. Here's another question. I came with a student visa. How can I apply for my green card?
So if you came on a student visa, you would still have to have eligibility. That means a petition to apply for the green card. Now, who can petition for you? There could be a family petition. If you get married to a U.S. citizen, or you have a parent or another relative who is a U.S. citizen or green card holder. It could be an employer. Maybe you find a job, an employer who's willing to sponsor you for the green card. Or maybe you want to self-sponsor. Now, self-sponsorship means that you can petition for yourself. That can either be through investment. That means EB-5, you invest at least $800,000 US into a US business. It could be EB-1, which means that you are a person of extraordinary ability. There's 10 criteria, and you meet at least 3 out of those 10 criteria, which means you've won awards related to your expertise, or you've been mentioned in the newspaper, or you've published articles in journals, or you've been a very important member of a distinguished organization. So there's a lot of different criteria. You have to meet at least 3 out of 10. There's also what's called the National Interest Waiver, or NIW. That means you don't have to have a job offer. You don't have to have those 3 out of 10 criteria, but you do have to show that your presence here in the United States is beneficial or helpful to the United States as a whole. Okay? And so that means how is it that your presence will help the United States as a whole? Are you in a STEM, which means a science or technology field that'll help the United States be more competitive in that field? Have you started a business with hiring US workers? And if you're not in the United States, those workers lose their jobs. Are you contributing to the US economy? Is what you're doing helpful to the national security of the United States? So there's a lot of different ways to show you're helpful to the United States, but you should have an attorney evaluate your situation and your CV to see if you might qualify.
And have you ever known a freshman who would be eligible for some of these visas?
Well, I mean, if you are 19 years old coming to the United States for your college degree, then it's probably unlikely you'll be able to go through these processes unless you have a wealthy family member who can gift you the investment money, or you have a family member in the United States who's a US citizen or green card holder to petition for you. Now, if you already had experience in your home country before you came to the United States for your education, then it's maybe if you can find a job, an employer willing to sponsor you, you can use that previous experience to qualify for the green card here. But the important thing is you want to maintain your non-immigrant status. That means you're maintaining your student status so that you're not becoming illegal. That would make you ineligible for the green card.
Thank you for that answer. I have another question here. I applied for AOS with Matter or Quilantum, that may be, I'm not sure what that is, whether that's an attorney. They got denied in 2018. I applied for the waiver, which I got approved in January 2024, and I'm just waiting for for the Juarez interview. Can I apply for PIP instead?
Okay, so matter of quolantum means that you were waived through into the United States. Maybe you were sitting in a car and then you came up to the border. The Immigration Service just allowed the car to enter the United States. So technically you didn't sneak across the border, but also you don't necessarily have a visa in your passport that you showed to immigration to enter the United States. And usually under a matter of quolantum cases, you don't have any proof that you were admitted into the United States except for your own word. Now, the Immigration Service usually does not approve these quolantum cases because there's no proof that you entered legally. You could have just made up a story. So that's why usually in your situation, you would go through the waiver process, the I-601A, which if approved, allows you to go overseas to your interview at the US Embassy in Mexico without having to, with all of your illegal presence in the United States forgiven. Now, if you are married to a US citizen, and this green card process is based on that marriage, and you don't have a disqualifying criminal record, which you shouldn't because you got the waiver approved, then yes, you should be able to do the PIP, new PIP process. Now, that process should be announced in the next few weeks, and it's taking about 1 to 2 years for Juarez to schedule those interviews. So this new process will definitely help you rather than going through, waiting for that interview, and leaving the United States.
Thank you for that answer, Attorney Francis. This is Margaret W. Wong and Associates. We are immigration attorneys in the U.S. We have offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. If you wish to arrange a consultation, you may call us at 216-259-8897. That's 216-259-8897. We do have another question here, and it seems similar to a previous question, but this person is a green card holder and wonders if they can bring their spouse to the U.S.
Yes, so spouses, parents, and sons and daughters, and brothers and sisters can petition for their family members to come to the United States. Okay. The first step is to file the I-130. That's the petition for family relative, alien relative. Now, the filing date of the I-130 gives you what's called a priority date. It sets your place in line for a green card number. A couple of years ago, there was no place in line. There was no waiting for spouses of permanent residents. It's just like being married to a US citizen. There's no waiting in line. But this past year, the immigration started using the quota system to force people who are married to green card holders to wait in line. So even though you file the I-130 now, it might take a year or two for that I-130 to be approved. And then your spouse might have to wait maybe 1-2 years before they can get their visa interview at the embassy to come to the United States. Now, if you're able to become a US citizen, to naturalize while she's going through this process, then you can upgrade that I-130 to marriage to US citizen, and then there's no waiting in line, no quota.
Thank you, Attorney Francis. This is, again, the immigration law firm Margaret W. Wong and Associates, with offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And so here's an interesting question. And it's, we hear this a lot, that the process of waiting for an approval from the government takes a very long time. So this question is, why is my green card taking so long to arrive to me?
Well, it could be, the first basic reason could be that maybe because of the quota system, you're not eligible to be approved yet. You're still waiting in line before the Immigration Service is even allowed to approve the green card. Or number two, it could be because of background checks or administrative processing. The Immigration Service is going through their usual checks, or they're just not processing the case very quickly, even though they could approve it at any time. So option number one, like I said, some categories, which are employment-based categories or family-based categories that are not marriage to US citizen, that are not US citizen adult child petitioning for a parent, there's a quota system. You have to wait in line. You're allowed to apply for the green card earlier so that you can apply for a work permit in advance, but that doesn't necessarily mean that the Immigration Service can approve the green card right away. You might have to wait in line for your priority date to become current, for your green card number to become available, okay? And for the second type of case, let's say you are married to a US citizen. You filed the green card application. Now, maybe you're waiting for an interview. The Immigration Service will schedule interviews for certain cases to make sure that you and your spouse are living together, that's a real marriage. And some offices have a lot of cases, and so they're just waiting in line for an interview. Or it could be after you've already been interviewed, the Immigration Service is just taking its time to process your application.
Thank you for that answer, Attorney Francis. This is Margaret W. Wong and Associates, the immigration lawyers in Cleveland, Ohio, with offices in Atlanta, Chicago, Columbus, Nashville, New York, and Raleigh, North Carolina. Here's a question that follows on to all of our offices around the country. This person says, I'm in Boston. Can I use your services from Boston?
So immigration law is federal. That means that as long as the lawyer is licensed in some state, they can practice immigration law in any state. The law is the same. So that means that we take cases from all over the United States. Gordon has already mentioned we have offices in New York, Columbus, Nashville, Atlanta. We have offices all over the place in the United States. So we take cases from anywhere. We can do a consultation over the phone. We can do a consultation over Zoom or Teams, or in person at any of our offices. So if you give us a call, we can schedule and see if we can help you.
Thank you for that answer. Here's another question, Attorney Francis. How long will it take to renew my work permit? Already, they've been waiting for a year.
Okay, so the first work permit is usually quicker. The renewal, the Immigration Service sometimes takes a lot longer to process because they know that the renewal for most categories, there's what's called a 540-day automatic extension using the receipt. So let's say your work permit expires next week. You apply for the renewal before the expiration date. In about 2 weeks, you get the receipt notice from immigration in the mail with the new case number. That receipt notice will say that your employment authorization is automatically extended for 540 days, which means a year and a half. Now, you can use that receipt notice plus your expired work permit to renew your driver's license and to continue to work. And because the Immigration Service knows that you have this automatic extension, they're taking their time to issue the new card because you already have this work authorization. So that's why it's taking over a year for these renewals, and their focus is on the first work permit, getting people those first work permits approved. If you want to try to expedite it, then you can submit a request, but the Immigration Service isn't really paying attention to those right now.
Thank you for that answer, Attorney Francis. Along with Attorney Francis, there are 13 attorneys in the Margaret W. Wong and Associates law firm. We are an immigration and criminal cases law firm, and we have offices, as we've said, around the U.S. If you wish to arrange a consultation, please call 216-259-8897. That's 216-259-8897. Now, here's a good question for people who are wishing to travel outside the country. Can I travel outside the country without my green card?
Well, I mean, the question is, how are you eligible? Anybody can travel outside the United States. The problem is returning to the United States. How do you return? Now, if you are a permanent resident, then you would need your green card or proof of your permanent residence in order to re-enter. So if you have your green card, but it expired and you're waiting for the renewal, you filed the renewal, the I-90, I would recommend you get what's called an I-551 stamp in your passport, because that's proof of your permanent residency. You can use that to re-enter the United States. And so you can make an InfoPass appointment at the local immigration office, or you can try, which you can do online, to get this I-551 stamp in your passport. Now, what if you are applied for the green card and you're waiting for the green card to be processed? If you leave the United States without permission, you will automatically abandon that green card application. You have to apply for what's called advanced parole. That's on form I-131, so that you have permission to travel outside the United States without canceling your green card process. Now, you can also apply for advanced parole if you have a DACA approved, or if you're waiting for your asylum case to be processed, you can also apply for permission. You can also apply for permission if you have TPS approved, but that actually gives you a travel permission document, not advanced parole. So it's like you came in on a visa rather than advanced parole. So those are usually the most common ways for you to get travel authorization.
Thank you so much for that answer, Attorney Francis. Again, this is Margaret W. Wong and Associates, the immigration law firm. If you wish to arrange a consultation, please call us at 216-259-8897. That's 216-259-8897. Please visit us on the web at www.imwong.com. And also, you may find us on Facebook and YouTube. You can watch our various YouTube and Facebook videos on various immigration questions. So thank you so much, Attorney Francis, for your time today. And we will see, we have these Facebook programs every Wednesday at 9:30 in English and Spanish, and then on Thursdays at 12:30 Eastern Time. Thank you.